Hey everyone, it's Marianne from the New York City Organization of Public Service Retirees. I want to do a series of videos on labor law because there's a lot of misinformation about the bill that Councilman Barron, Intro 1099, has introduced is illegal, as you've all heard from City Council Speaker and several City Council persons repeating the same big lie. And then you also hear Alan Klinger, the MLC, DC 37, the UFT, say that they represent retirees, which they don't. And I'm going to start this small. We're going to do this in little pieces so that you don't get lost. I'm going to try to keep these short. So here we go. I want to share with you a case from 1977 called Chemical Workers versus Pittsburgh Glass. It's decided in 1971. In this case, this case was argued in 71, but it went through a series of appeals. When it was originally argued, it was about the time that Medicare became available in 1966, 65, 66. And what happened was Pittsburgh Glass was offering health care to the workers. And when Medicare became available, they said, well, this kind of makes our plan obsolete, so we're just going to end it. And the chemical workers were like, no, you can't do that. So they tried to get them to change their mind, and they wouldn't do it. And so they filed a lawsuit against Pittsburgh Glass. They were saying that the union was saying they represent retirees. So the National Labor Relations Board got involved. I want to show you a little bit of the argument. It says a labor organization that was the exclusive bargaining agent for employees working on hourly pay rates at one of the respondent company's facilities had negotiated with the company an employee health insurance plan in which retired employees participated. Upon enactment of Medicare, the union sought midterm bargaining to renegotiate the insurance benefits for retired employees. The company maintained that Medicare made the insurance program useless and the retirees' benefits were not a mandatory subject of collective bargaining, stated that it would offer each retiree a stated monthly amount towards supplemental coverage. When, despite the union's objections, the company made the offer, the union filed an unfair labor practice with the National Labor Relations Board. The National Labor Relations Board concluded that the company was guilty of an unfair labor practice in violation of Section 8A5 and 1 of the National Labor Relations Act and issued a cease and desist order. The NLRB held that the benefits of already retired employees were a mandatory subject of bargaining as terms and conditions of employment of the retirees themselves and alternately the active bargaining unit employees. It also held that the company's establishment of a fixed additional option in and of itself changed the negotiated plan of benefits, contrary to Section 8D and 8A5 of the Act. The Court of Appeals for the Sixth Circuit disagreed with the NLRB and refused to enforce the cease and desist order. What they held was that retiree benefits are not within the meaning of 8A5, 8D of the NLRA, a mandatory subject of bargaining on the terms and conditions of employment of retirees. The collective bargaining obligations extends only to the terms and conditions of the employment of employers' employees. And the term employee has its own ordinary meaning, someone who works for another for hire, which excludes retirees. We've been saying the same thing because those provisions are also under the New York City collective bargaining law and the Taylor law, which are a little bit different than the NLRA, but they are still in line, and this case still carries. Collective bargaining is an obligation, is limited to the terms and conditions of employment of the employees in the bargaining unit, appropriate for the purpose of collective bargaining. Retirees are not members of the unit represented by the union because they are no longer working, nor could they be members since they lack substantial community interest with the active employees in the unit. We keep saying this because the needs of a retiree are different than those of an employee. This is why you don't typically have supervisors and ordinary employees in the same bargaining unit. Their needs are different. So even in industry practice of bargaining over retirees' rights exists, which is disputed, that cannot change the law and make into a bargaining unit employees those who are not. Retirees' benefits are not a mandatory subject of bargaining as terms and conditions of employment of the active employees remaining in the bargaining unit, although their future retirement plans are. Retirees' benefit do not vitally affect the terms and conditions of employment of current employees. The benefits that active workers may reap, including retired employees under the same health insurance contract as themselves, are speculative and insubstantial at best. The relationship with the NLRB asserted exists between bargaining in behalf of retirees and negotiating of active employees' retirement benefits is equally too speculative a foundation on which to base an obligation to bargain. So in this case, they found that the active workers cannot, that union cannot represent a retired person. So there's a few pieces to this case that I do want to go to, and I want you to be able to hear it for yourself. And then I'm going to break this apart in small pieces just so that it's not too long. Now, you could actually hear this case, but for this, I do want to jump to
employees for purposes of their retirement.
Well, Mr. Cohn, were the benefits that the employer had been paying before the change or before the offer, were they required by a collective bargaining contract? Were they part of the terms of a collective bargaining contract?
They were required by an agreement. What the company did was they negotiated a collective bargaining agreement, and then they, at the same time, executed a side agreement covering
with the union.
With the union.
So that anyway, it's a contractual matter.
That is correct.
Now, what if the employer had just instead of changing the payments, had just stopped them? I suppose the individual retired employees would have had a cause of action against him.
That is correct.
Wouldn't the union too?
For breach of the collective bargaining agreement, perhaps probably under 301.
Is there some doubt
and
about
301
No,
is breach of contract.
I do not think that there is any
You
doubt
don't
about
breach of the collective bargaining agreement, breach of the side agreement.
breach of the
301
side.
breaches of any agreement.
That is correct.
Now, does your position also include the proposition that the union could negotiate a modification of the side agreement on the retirement benefits, reducing them, and bind the retired employees? Here's an agreement that's been made. The promise is to pay X, and there are employees who retire. The union and the employer get together, and they all agree that the fund isn't going to stand it or something, or that it's desirable to lower retirement benefits generally, and they lower them. Is the union a representative of those retired employees for that purpose?
I think that the logic of my argument would.
And Mr. Comey is the attorney for the NLRB.
However.
And how does that work out when the employee, when that
Well,
retired employee has absolutely no voice?
Well, I think you then get into problems of breach of the duty of fair representation.
Yep.
The question as to whether or not if the thing is vested, any such agreement is going to be enforceable. However, with the employer free to act unilaterally, you've got the same problem. The only question is whether you reach it as a result of the employer's unilateral action or as a result of collective bargaining.
And that's what we've always said, because we always taught you that the unions should never have pushed retirees to say that retirees are not protected by the unions, because basically then what we're saying is, well, then I guess the city could just screw you all on your own without the protection of the union. This is why union leaderships in the past have always urged the union leaders taking their places to never touch a retiree benefit ever, and to never allow it to be negotiated down. This is why bad things happen. It was fine to modify, slightly tweak to improve, but once you start going down that rabbit hole of diminishing a benefit, you've lost. And to have to insist that why are you capitulating to mutually agree with the city to diminish a healthcare benefit for a retiree, you'll start to hear some of those arguments in the later clips, but let me continue.
I think that
but there are always contractual remedies against them. I mean, if he lowers the, if he doesn't live up to his agreement, the retired employees can have an action against him.
Well, I think that they would.
And your objection is that he's raising the benefits.
Well, they could also have an action against the union for breach of the duty of fair representation. However, we don't have anything like that in this case, Your Honor.
Going back to the hypothetical that Mr. Justice White suggested to you about the union exercising this power to negotiate a reduction in benefits previously agreed upon, seems to me I recall some Court of Appeals cases that have referred to this in terms of a possible breach of the fiduciary duty of the union toward its members.
Yes, Your Honor. I think that a union would bring itself afoul of that line of decision.
Would the board have jurisdiction of that, or would that be a suit under 301, or where would it be?
And so, and that was one of the things we were also saying is we should never have been put into a position as a retired person to say that the union was not protecting us and our benefits. Because what are we saying? Then if the union doesn't represent a retired person, which they don't by law, but that's not something you wanted to say out loud, then you're basically saying that the management can just screw you all by themselves. And what the active worker should have been looking at, and the active union leadership should have been looking at, is I should be protecting my future from diminishment. And especially from people that retired from before you that don't make a lot of money, as most retirees that retired before you don't. 2/3 of DC 37 retirees make under $26,000 pensions. 1/3 of them make under 12. I have a nurse that retired in 1987 from HHC. Her pension is $7,100 a year. I have a firefighter who retired in 1979 after about 30 years of service, and his pension is $26,000 a year. This wasn't the people that you should have been messing with their benefits. We earned and paid for that, but more to come. I'm going to end this here. I want you to think about what you heard, and then I'm going to do another few shorts to start showing you that unions do not collectively bargain for for retired workers. They can collectively bargain for active workers in their units and those active workers' future retirement benefits. And I also want to prove to you that the speaker is misleading you all by saying that the legislation is illegal for Intro 1099, because it is not. She's saying that it would inhibit collective bargaining, and it would not. Thank you.